Good afternoon. This is Vivian Young with 1000 Friends of Florida. We'd like to welcome you to the Dr. John M. DeGrove Community Steward webinar series. Today's webinar is on the 2013 Florida Legislature, what legislation passed and what bills failed this session. This event has been approved for AICP CM legal credits and also for Florida bar credits. You all should have received an email with this information as well as a link to the PowerPoint for today's presentation. 1000 Friends of Florida is a statewide not-for-profit organization. We were founded in 1986, and we bring these webinars to help educate people on planning and conservation and housing issues facing Florida. The webinar series is sort of devoted to the memory of Dr. John M. DeGrove, who was one of the founders of 1000 Friends of Florida and is also very widely known as the grandfather of growth management in Florida and nationally. We do have a monthly webinar series. Our next webinar is going to be Wednesday, June 12th from noon to 1:30, and it's on the Florida Greenways and Trails Close the Gap campaign. You'll find out during the presentation that this program has received significant funding from the Florida legislature, so there is a great deal of interest in this program right now. If you want to find out more about 1000 Friends activities, you can sign up for our alerts, and you can also follow us on Facebook and Twitter. I'd like to briefly introduce the presenters today. Charles Pattison is president of 1000 Friends of Florida, and he's been in that capacity since 1998. And he has extensive growth management experience throughout Florida and then also in Virginia and North Carolina. Lester Abinger is a board member emeritus of 1000 Friends of Florida and past president of our organization. He is chairman of the Trust for Public Land, Florida Advisory Council, and a number of other statewide organizations and institutes. Janet Bowman is the Director of Legislative Policy and Strategies for the Florida chapter of the Nature Conservancy. She also served as 1000 Friends Legal Director from 2001 to 2006. And Jamie Ross is 1000 Friends Affordable Housing Director. She has been in that capacity since 1991. She's also president of the Florida Housing Coalition and is involved in a number of statewide and national organizations and boards related to affordable housing. I just wanted to take a moment to let everybody know that you can write in questions. If you look on your control panel, there is a questions box. If you type in your questions, we will, to the extent possible, ask them at the end of the webinar. If your question is directed to a particular presenter or a particular slide, if you could indicate that just to make it a little bit easier for us to figure out who to ask. At this point, I'd like to turn the presentation over to Lester Abinger, board member emeritus of 1000 Friends of Florida, and he is going to give us a brief overview of the session in general. Lester, can you hear me?
Yes, ma'am. Ready to go. Good morning. Thank you all for joining us. We're going to start our overview of the session with the budget, which is, we have pointed out in previous webinars, is the only bill that the legislature is required by the Constitution to pass. The old adage that a rising tide lifts all boats is probably apt for this session of the legislature, as Florida has emerged from the real estate recession. State revenues are up, and that made budgeting decisions much, much easier than they have been during the past 6 or 7 years when we began the session with projected deficits and therefore painful choices and difficult budget cuts had to be made. The House and Senate priorities, again, as most people on this call probably know, the governor proposes a budget, then the House develops a budget, the Senate develops a budget, and the House and Senate reconcile those three budget proposals. Those were done this year, in my experience, without too much acrimony. The system, such that it is, worked as it was supposed to, and the differences at the end of the day were worked out in time, so that the legislature was able to adjourn within the requisite 60-day time period. Of particular interest to conservation and growth management advocates were the portions of the budget that related to land conservation and environmental protection programs. We've discussed in past calls the funding for the Florida Forever program, once a national model for land conservation and funded under the leadership of Republican and Democrat governors at a level of some $300 million a year. This program was a terrible casualty of the need to make budget cuts in light of projected deficits that the state had. This year there is some funding for Florida Forever in the budget, but I think those of us who are presenting today would argue that this is a pitifully inadequate level of funding. But we are pleased that there's funding at all. The governor had recommended funding this program at $75 million a year. He proposed using $25 million of general revenue money. The easiest way to think about that is proceeds from sales taxes, and $50 million from the sale of yet unidentified state surplus lands. The legislature, at the end of the day, appropriated $70 million for the Florida Forever program, $10 million of general revenue, $10 million from the Land Acquisition Trust Fund with proviso language, which is used to direct agencies how to spend the money, that $10 million should be used for military-based buffering land acquisition projects, and then $50 million from the sale of surplus land. There were other land acquisition and protection appropriations items in the budget, the most significant of which was $70 million for Everglades restoration. There was also a little bit more than $11 million to fund the Rural and Family Land Program, which is largely for conservation easements. Janet Bowman is much more knowledgeable about that program than I am, so if I'm misspeaking as to the use of those funds, I'm sure she'll take great pleasure in correcting me. There was $10 million for springs restoration. I think probably will be directed to North Central Florida. And then a little surprise of $50 million, which was in the DOT budget, to complete or link together a cross-state in the Central Florida area, bicycle trail. Some of that money will be used for land acquisition, but most of it will be used for infrastructure. So that, in short, is the land spending portion of the budget. I wanted to speak on just briefly on a few other issues, again, because as we've discussed in these previous calls, everything happens in context in the legislature, and so it's important to understand the political and the policy environment in which the legislature was working. One of the major issues, again, as I think most people on this call are no doubt aware, was the proposed expansion of the Medicaid program. This would have enabled the state to take advantage of billions of dollars in federal funds to expand the Medicaid program to cover some 1 million currently uninsured Floridians at or below 138% of the federal poverty level. The governor, in a courageous decision, in my view, recommended that the legislature use those federal funds to expand the Medicaid program. The Senate developed a plan to do it, although without delving into the details, would not have spent that money on what we think of as the Medicaid program, but would have used the private insurance markets much like the model of the Florida Healthy Kids Corporation in order to draw down the federal funds and to provide the insurance to those 1 million uninsured Floridians. But at the end of the day, the House and the leadership, the Speaker, made a decision that they didn't think it was appropriate for the state to take advantage of this federal funding. There's been some discussion of the possibility of a special session of the legislature to address this issue. Although in my experience, special sessions don't tend to work out too well unless there's a deal that's been agreed to by the three parties, the governor, the House Speaker, and the Senate President, before they ever call the legislature back. In light of the action by the House, I just think it's unlikely that they're going to move on that. There were some reforms also of the Citizens Property Insurance, which is the state insurance pool. I think this is important to people who care about land conservation and growth management, because this program essentially subsidizes people who live in high-risk areas of Florida. Some 1.3 million policyholders, and the Citizens Insurance program is a colossal bet with your money in mind that there won't be a hurricane in Florida. Because if there is, this company, this state company is underfunded, and the recourse is that every insurance policyholder in Florida can be assessed to cover up the losses. So things that can be done to restructure and downsize the Citizens Property Insurance Company, I think are good things. And while some of these reforms were at the margins, I think it shows an increasing recognition by the legislature that this is a problem that needs to be addressed. It's not going away. There were significant, as we predicted during our pre-legislative session webinar, significant ethics and elections reforms. The elections bill, House Bill 7013, addressed some of the changes that restricted access to the polls to voters, particularly with respect to early voting and the sites for earlier voting. The early voting has been returned to the previous 15 days. They also address the issue of the sites for early voting, and in the ethics reform legislation addressed the issue of campaign contribution limits. They raised those. They're now $500 for an individual or a corporation. They're raised to $3,000 in statewide elections and $1,000 in other elections. There's some sentiment that the governor may veto that. It also increased campaign reporting requirements and abolishes what they call committees of continuing existence, these phantom corporations that are used to funnel money into campaigns. I think for now that covers it, and I'll look forward to answering your questions. Thank you.
Okay, Vivian, this is Charles. Thanks for listening in. I'm going to go ahead and cover the growth management legislation. Fortunately, nothing quite as dramatic as what we saw 2 years ago in 2011. Let's begin with House Bill 319. This did pass. This was something that Thousand Friends opposed with the cities and the counties just because we saw it as an intrusion into home rule authority, but it did pass, so here are the particulars. It does require anyone either using transportation concurrency or any alternate to accept good faith offers to pay proportionate share impacts for transportation related impacts from new development. It would also eliminate the possibility that such a project could be denied on transportation related grounds, although the ability to deny something for other reasons was still left intact. This is what we had called the pay-and-go provision. It did have language that protected the mobility plans that are now in effect in Pasco, Alachua, and Jacksonville, Duval. As was done with the transportation concurrency requirement, if local government is using one of these alternative programs and to substitute for concurrency like mobility planning, they would also be required to use the pay-and-go provisions. This was the bill that passed. The Senate companion wasn't passed, but that was Senate Bill 972. Let's go to House Bill 537. This is sort of a residual from the Amendment 4 fights from a couple of years ago. And in this case, the legislature was making it very clear that there were to be no referendums on development orders, including plan or map amendments, unless one of these 4 items were in effect. One was that it affected more than 5 parcels. The other was something that was authorized in the charter as of June 1st, 2011. They made it clear that general provisions for allowing for referendums were not sufficient. And then an interesting final amendment. There was some controversy last year about a late filed change to the Ag Enclave language that specifically applied in St. Johns County. That was deleted through this legislation. Let's go to Senate Bill 50, Senator Negron's Citizen Participation Bill. This basically has required that the public be given the opportunity to speak prior to action by elected boards, although it does not have to necessarily be at the meeting where a final decision is made. Then public-private partnerships, and that should be House Bill 85 at the top instead of Senate Bill 85. This was a kind of an overhaul of the existing public-private partnership language. It could have some growth management implications. We were watching it initially because we thought there might be some overrides of local planning or zoning controls, but that did not happen. It does call for a task force to recommend guidelines to the legislature for future public-private partnership agreements. Those are to be presented by July 1, 2014. And then it has a series of procedures for dealing with solicited and unsolicited bids for public projects, and we listed those in the second bullet above. And there was finally an additional provision for county road projects using public-private partnerships. Let's go to House Bill 7019. This was partly done to address a FEMA concern from a couple of years ago where flood insurance questions were raised about whether flood insurance was being conditioned for appropriate permit approvals. This clarifies that and requires counties and cities to attach disclaimers on any of their permits that they are not, by issuing those permits, waiving state or federal requirements. It also contained those referendum prohibitions from House Bill 537. And another section defines high-speed rail communication facilities and provides that the Florida Rail Enterprise organization can issue permits inside existing or new high-speed rail right-of-ways for what's called communication-related facilities. Those would be issued regardless of local planning or zoning authorities. It does put timelines on the consideration of the applications as well as when the agencies have to act. Let's go to the next part of this slide. There was a section inserted dealing with septic tanks in the Keys. Many of you know the Keys are in the process of implementing an advanced wastewater treatment central sewer system. And the questions come up about septic tanks that may or may not be installed between the time today and the later date for connection to central sewer. There are certain provisions that were added here, and I'm not going to go into the details, but this should be of interest to people following development issues in the Keys. Let's go to the next. Senate Bill 1770, this was the big Citizens Property Insurance Bill. There were quite a few changes, but the two that I wanted to mention that have growth and development implications were these two. One is that no citizens insurance would be issued for any new or substantial improvement for projects seaward of the DEP Coastal Construction Control Line. And then also no state insurance would be provided for property that's in the Coastal Barrier Resources Act designation. That's a federal designation. House Bill 203, this may be of interest to some of the local governments. There's a specific prohibition on the charging of any fees for specific agricultural activities if they're covered by BMPs or any rules that DEP, DACS, the Corps of Engineers, or EPA would have in place. House Bill 357. This is actually a manufacturing streamlining bill. It's meant to make it easier for local governments to approve larger scale manufacturing related projects and not require the applicants to come back for future approvals. DEO is directed to develop a model ordinance, although local governments can submit their own programs earlier than this. It does require coordination with other state agencies that are issuing permits. It limits how local governments can, request additional information, and sets up a timeline for 60-day approval or rejection processes. That's it for the legislation that passed. Let's look briefly at some that did not, that had growth implications. House Bill 321 did die. This was the one that had the 3-year moratorium on transportation-related impact fees and concurrency. That did not pass. It had been limited rather substantially at the end. It would have only applied to commercial properties that were 6,000 square feet or less. But again, it did not pass. Senate Bill 786 was an idea for resurrecting the expedited review process that had been in place prior to the changes made in 2011. It really would have sped up the already expedited process for these particular local governments, but again, it did not pass, including the fairly debatable question that this amendment or bill would have raised. House Bill 673 did not pass. This was an attempt to put into statute some recent Supreme Court results. I think the idea was that it was to incorporate language, new terminology, in particular things identified as reasonably necessary or roughly proportionate when development impacts were being considered. Again, it did not pass. This House Bill 89, Senate Bill 348 was not heard and died. This would have reestablished an urban infill grant program that had been previously abolished, but this got caught up in the budget and there were no funds available for it. Senate Bill 1698 was a bill that would have eliminated a rarely used, I don't think it actually had ever been used, piece of DRI law that allowed local governments to be certified to handle developments of regional impact. And again, that did not pass. I believe that's it, Vivian. I'm going to turn it over to Janet Bowman with the Nature Conservancy to talk about environmental legislation.
Good afternoon. I'm Janet Bowman with the Nature Conservancy, and I'm going to start out with water resource legislation. As there has been for the last number of years, there have been some pretty substantial water bills passed, and this session was no different. The first bill I'm going to talk about, House Bill 7065, Everglades Improvement and Management, combined some appropriations for the sort of Central Everglades settlement that Governor Scott and the Department of Interior came to an agreement a year or so ago, with provisions modifying the agricultural privilege tax that is levied on sugar growers in the EAA. The bill adjusts the agricultural privilege tax so that it's $25 per acre until November 2026, and then there's some step reductions until November 2036 when the tax is substantially lowered to $10 an acre. Importantly, the bill makes a legislative finding that payment of the privilege tax and continued implementation of best management practices by agricultural growers in the area fulfills the polluter pay requirement of the Florida Constitution. And finally, the bill appropriates $12 million in general revenue and $20 in Water Management Lands Trust Fund for funding the Restoration Strategies Regional Water Quality Plan. And I just point out that Everglades funding in the budget ended up being $70 million in total, very significant appropriations. The next bill is Senate Bill 948, Water Supply, by Senator Denise Grimsley. And this particular bill came from DACS, from the Department of Agriculture and Consumer Services, and was structured to give agriculture more of a seat at the table in water supply planning with water management districts and local government. The bill provides that agricultural water supply projections must be based on best available data, and that water management districts must consider the data provided by DACS. It authorizes DACS to establish an agricultural water supply program based on a 20-year planning period that gathers water supply demand data across crop types. And this effort was provided some funding in the Appropriations Act. The next bill, Senate Bill 444, deals with ocean outfalls in southeast Florida. And over the past 3 or 4 years or so, there's been an attempt to extend the deadline for the local governments in that area adopting advanced wastewater treatment for discharge through the outfalls. Unlike the past couple years where the bills failed, this year didn't attempt to modify the deadlines, but instead modified how reuse requirement is satisfied by the local governments. And it allows them to calculate reuse that's produced over their entire service area to meet their obligation instead of just within the service area that serves the outfall. It also allows some through the outfall after the drop dead deadline for removing effluent. The next bill, HB 999, environmental regulation, was probably the bill that generated the most controversy over the course of the session. This was an environmental train bill by Representative Petronis that includes a shopping list of regulatory relief measures. And the bill sort of kept growing over session. Pieces were removed, pieces added, all the way up to the very end. And in fact, the bill, I think, was one of the last pieces of legislation that was voted on before sine die. The bill includes limitations on the ability of local governments to ask for additional information for permit applications, to no more than 3 requests for information. It exempts from wetlands regulations certain farm ponds and wetlands created from unauthorized flooding from adjacent property. It provides that natural gas pipeline permitting is subject to the expedited permitting process. It includes a number of favorable sovereign land lease consent of use provisions for boat shows, for marinas, and multifamily residential docks. It prohibits water management districts from reducing the permitted amount of water withdrawals that are provided to a utility that is using certain kinds of alternative water supply, namely RO. The bill was notable for some provisions that were removed from the bill prior to its passage. These included definition of the ordinary, the mean flood line as an indicator for wetlands permitting, and also at the end of the day, a provision was removed from the bill that would have exempted Chapter 298 districts from local wetlands permitting ordinances, and a provision that would have preempted the enforcement of new urban fertilizer application ordinances that were enacted after the beginning of the legislative session. A final controversial provision that did remain in the bill at the end of the day was one that ratifies several sugar leases that were approved by the Governor and Cabinet earlier this year that have been challenged by the Florida Wildlife Federation. The next series of bills deals with state lands, the use of state lands, and generally there have been a number of bills filed over the last couple years that address surplusing and that also address when and how the state can buy and manage state lands. The first of these bills, House Bill 1145, primarily dealt with how the state leases space. But it contains a couple provisions dealing with land inventories and the sale of surplus lands that are relevant to conservation lands. First, it requires the Department of Management Services and DEP to publish yearly reports that include a list of surplus lands candidates. Second, and really most importantly, DEP is given the authority to use sales techniques other than competitive bidding to surplus parcels with a market value over $500,000 if the competitive bidding process is unsuccessful, or for parcels less value, they can use these techniques in any case. And these include exclusive listings, negotiated direct sales, auction, and other reasonable means. And this is notable because in the appropriations for Florida Forever, DEP is directed to, over the course of this summer, to come up with a list of potential surplus candidates for what's now conservation land that they determine to be no longer needed for conservation purposes. So this would allow them to, once those parcels are identified and go through the surplus process, to sell them in a different fashion than they are currently. The next bill is 7087, House Bill 7087, is the Department of Agriculture's agency bill. And there were a couple of provisions I wanted to highlight in that bill. The first transfers the management responsibility for Babcock Ranch, which was operated by a nonprofit entity, back to sort of state management, state and local management. It's going to be managed by the Florida Forest Service, and the Lee County portion is going to be managed by Lee County. The second provision, and really one of the most important, is authority for Department of Agriculture and Consumer Services and the Fish and Wildlife Conservation Commission to enter into a memorandum of agreement to develop best management practices for wildlife protection, endangered species protection, to be implemented by the agriculture industry. And once these BMPs are adopted, this bill would preempt the ability of local governments to enforce on ag land any wildlife protection provisions that conflicted with these BMPs. So the BMPs are intended to really define and I think assist agriculture in kind of upfront devising land management strategies that help them to address endangered species. Moving on to bills that failed, and I would say this year I think there were a number of bills that failed during the process, which I think is in contrast to the last couple of years. The first is Senate Bill 584, Purchase of Land by a Governmental Entity. This bill would have severely restricted the ability of the state, county, and local governments to buy additional conservation land by requiring that an identical amount of land be put back on the tax roll before new conservation land could be bought, and then requiring these governmental entities to demonstrate that there's adequate money on hand to pay for the management of their entire land portfolio, and that they have money on hand for the newly acquired land. So this bill may come back up. There's certainly concern by many legislators that the state owns too much land, and these kinds of measures are sort of directed at that sort of philosophy. The next bill, House Bill 33, Senate Bill 466, that also failed, would have allowed a particular kind of exchange to occur where the state would have been required to consider a request to exchange state land for land owned by a private landowner, and the bill would have sort of bypassed the normal Acquisition Restoration Council process of determining that the exchange provides a net environmental benefit. The next bill, House Bill 789, the Springs Revival Act, was filed sort of late in the day to address springs protection, and it required water management districts to identify all magnitude 1 or 2 springs in their jurisdiction that are in decline and develop 5-year restoration plans, to submit quarterly reports to the Governor, Senate President, and House Speaker. This bill was never taken up, but late in the day during the budget conference, the House and the Senate agreed to put an additional $10 million for springs protection into the budget. So there is beginning to be, I think, more of a legislative recognition that that special attention needs to be provided for springs protection. And that's my list.
Okay, thanks, Janet. This is Jamie Ross. I'm the Affordable Housing Director at 1000 Friends of Florida. And I'd like to add some context for those of you. I think most people on the line are probably engaged in environmental, conservation, transportation issues. I know sometimes I get that question, what is 1000 Friends of Florida doing with housing? Housing is a core program for us. It's an extremely important part of growth management. And of course it is recognized in the Florida statutes as such, as every jurisdiction needs to provide for the entire current and anticipated population, even those at the extremely low income level, and that's in 163-3177. So continuing with the context, when I came to 1000 Friends in 1991, we found that local governments were having trouble with this because it isn't all about money. It's about land use planning and using good planning tools, and of course we work with that and help folks with that. But it is also about money, and local governments saw that it was an unfunded mandate to be required to provide for housing their current and anticipated population without a funding source for that. So 1,000 Friends of Florida put together what is now known as the Sadowski Coalition by bringing a number of statewide organizations together who really had very differing interests. We had industry groups, the home builders and the realtors, and we had folks who really cared about extremely low-income people like Catholic Conference and Florida Impact and Florida Legal Services and the Florida Housing Coalition. And we're coming from different points of view, but they all came together to create landmark legislation, which was the William E. Sadowski Affordable Housing Act, which created a dedicated revenue source for affordable housing in Florida. And you see there on your screen there is a link for you. We have a website set up just for the Sadowski Housing Coalition and all of those materials. So what we do every year, and 1,000 Friends of Florida spearheads this every year as a facilitator, is we work to get the legislature to appropriate the funds that are in the State and Local Housing Trust Fund for the programs that are meant to be funded by the State and Local Housing Trust Fund money. And most of you, I think, on the line are familiar with the SHIP program because it's in every one of our 67 counties and our entitlement communities. That is the primary local government trust fund program that these monies fund. And then at the state level, we have the primary program being the SAIL program. This year, the Florida legislature had about $204 million available to appropriate for those programs. What I'm going to start talking about now is something that it was Senate Bill 1852, which was not the appropriation of those monies. Those monies that were in the state and local housing trust funds were actually swept to the reserves, which is kind of amazing because this was a year when there was no budget deficit. This was a year when we have an extreme housing need, and a year when all of that money could have created an enormous benefit to our economy. But the good news is in Senate Bill 1852, we did get an appropriation for both the SHIP program and the SAIL program. So what is it? So the $200 million and 80,474 that you see up on the screen there was Attorney General settlement money. So the Attorney General Bondi had was part of a massive national bank settlement agreement. In fact, our Attorney General was a leader in that. And during the legislative session, there was a smaller pot of money. It's a very, very large settlement. There was this sort of discretionary pot of money, as you see as that $200 million. Which needed to be appropriated by the legislature during the regular session. And the good news is that approximately $140 million, and I'm going to show you later it's really more like $160 million, was appropriated for affordable housing and did actually fund our state programs. But the next slide is going to show you that I'm just going to go through the appropriations that went for housing from the AG settlement bill, again, which was Senate Bill 1852. $20 million went directly to Habitat for Humanity. It's going to be going through the DEO for the acquisition and rehabilitation of existing housing stock. It's not to be used for new construction. And Habitat for Humanity is going to administer that with an RFP and distribute the funds to its affiliates, to the Habitat affiliates. There's between 15 and 60 affiliates in the state, and that's how that money is going to go. So it's a direct appropriation to a particular developer. Again, it is AG settlement money, not the Sadowski money. And with the Sadowski money, there is no appropriation to any particular developer. It goes to a program. So on the next slide for Senate Bill 1852, you do see that SAIL, which is a program, the state's program that is ordinarily or intended to be funded from the Sadowski Trust Funds, did get appropriations from the AG Settlement Bill, Senate Bill 1852. So you see now SAIL is the State Department Incentive Loan Program that's administered by the Florida Housing Finance Corporation. And you see that $50 million of the funds that are going for SAIL will be used to reduce rents on new or existing rental units, with 50% for elderly and 50% for units serving extremely low-income residents. Extremely low income is a statutorily defined term that's less than 30% of area median income. It's very, very low income. $10 million, another $10 million for SAIL to be used for the construction or rehabilitation of units where they're at least 10%, but not more than 25%. Are used for persons with developmental disabilities, and that statute that's referenced there is the statute that defines what that means, a person with developmental disabilities. There's 7 statutory defined groups that are developmentally disabled. Then we'll go to the appropriation to SHIP, which is on the next slide. So in Senate Bill 1852, SHIP did get funded, which is a big hooray because over the last 4 years, SHIP has not been funded. The legislature has been sweeping the SHIP trust fund money into general revenue because the stated reason because there was a hole in the deficit and they needed to use that trust fund money to fill that hole. Again, we didn't have a deficit this year. Had the SHIP money been appropriated according to the intended purposes, it would have been more like $150 million that would have gone to the SHIP programs to the 67 counties and the entitlement cities. But if you're a person that sees the glass half full, like me, this is a good thing in that we do have $40 million going out. We got money in the pipeline again for the SHIP programs. I imagine there are a number of you on the line who know, maybe with local governments where this has been a huge problem for you. You haven't even had the money to keep your SHIP administrator going. These functions have had to go to somebody else who already had their plate full with other things to do. So this is really good news that there will be a distribution this fiscal year of $40 million in SHIP funds. As you can see from this slide, there are restrictions on how that money is to be used. Again, it's not going to be allowed to be used for new construction. It's going to be for rehabbing or modifying owner-occupied units or helping with the purchase of an existing home. Housing counseling is a permitted use. Lease purchase is a permitted use. And you see implementing other strategies so long as they're approved by the Florida Housing Finance Corporation, which are related to foreclosure, which makes sense because this is the AG settlement related to the banks and the huge foreclosure crisis. So you also see that there's a provision that 20% of the SHIP money has to be used to serve people with special needs. And the first priority is going to be for persons, again, with developmental disabilities, those 7 statutorily defined groups in the Florida statutes, to be used for things like retrofitting to make it people's homes more accessible. Envision somebody's in a wheelchair, people to be able to stay in their homes. And they are limiting the admin money to the SHIP offices to 3%. Typically, SHIP offices can use 10% of their allocation for admin. 3% will be quite the challenge. And I'll go to the next slide. Now we're going into another, again, coming out of the AG settlement in Senate Bill 1852. There is a $10 million appropriation to help the issue of homelessness. There's going to be a competitive grant program that the Florida Housing Finance Corporation is going to run to provide this $10 million to nonprofits to purchase and renovate existing houses, or they can do new construction if it's for 15 units or less. That's going to be for the purpose of housing homeless people. And, of course, a priority given to the extremely low-income folks. The next appropriation is another $10 million that is specifically for folks with developmental disabilities. You might be seeing a pattern here. We have some concern in the legislature about folks with developmental disabilities, which is an important focus, because typically people with developmental disabilities are extremely low income, and there is a movement toward having people with developmental disabilities live in the least restricted environment as possible, and that takes funds to support their housing. So we have another $10 million to fund a competitive grant program for housing for developmental disabilities, and they're going to be specifically looking at nonprofits whose primary mission is to serve those that population with those grant funds. The reason I said earlier, that all adds up to $140 million. The reason I said earlier that you really could look at it more like $160 million that was appropriated during the session is because there's also from this settlement money $20 million that is going to legal services to provide legal aid for low-income folks and moderate-income folks who are facing foreclosure, and that really is for affordable housing, because the idea is that they're able to help these folks through their legal services to stay in their homes, to not lose their homes. That's one more family that is not in need of affordable housing. If they lose their home to foreclosure, then that's one more family that we need to house with some kind of a subsidy. So, because they're low income. So we've got that additional $10 million there, and another $10 million for capital improvements to domestic violence centers. And because it's for capital improvements, and I know a lot of folks aren't familiar, mostly because domestic violence centers, by their very nature, stay as a sort of an anonymous place for the safety of victims of domestic violence. But when folks need to go to a domestic violence center, they basically would be homeless if that center wasn't there. They're fleeing their home, a place they can't go back to, and they are folks who can frequently end up, typically women and children, will end up in homeless shelters, which we don't have enough of, and is not a good environment. So this is an appropriation that is going to provide very important shelter for the victims of domestic abuse. So the next slide, we're talking about the Sadowski State Mobile Housing Trust Funds, which of course I couldn't help talk about right away because this was the focus of our work, was to see that those funds were not swept. It was $204.13 million that was available for appropriation, and they did go into Florida's reserves. Again, that's something that we'll need to address next year. The AG settlement money is non-recurring money, so all that money I just talked about, all that appropriation from that settlement, while it's wonderful that we got SHIP funded and we got SAIL funded, that's great, but that's non-recurring money, so we have to keep our eye on our dedicated revenue source, the Sadowski Trust Funds, and that's where we'll be looking to fund those programs from next legislative session. So I'm going to move to another bill that's not about appropriation, but this was a priority for Thousand Friends of Florida. We talked about it in an earlier webinar that we were working on this issue this session, which was to close a loophole that was in Chapter 196.1978. On the next slide sets that forth. It ended up being House Bill 437. When we first started talking about it on the last webinar, it had different bill numbers, but as those things change, you get committee substitutes and so on. This ended up being House Bill 437, and this was a good thing because it closed a loophole that was really enabling for-profit owners, developers of affordable housing to take properties off the tax rolls just because of a change in the legal structure of how they were owned, and costing local governments unnecessarily to the tune of about $11 million just right now on the applications that have been made for tax exemption locally, which is not a good thing for affordable housing. You know, one of the things that we look at is, especially in the land use area of affordable housing, is the not in my backyard syndrome. We don't want people to not support affordable housing development, and if you're going to take all these properties off the tax rolls, it really would, I think, lead to people in the community, elected officials, not wanting to approve affordable housing developments because they would lose that important revenue from the taxes. So that's a really good thing. That was a good win this year, in that we had that on our agenda to pass, and it passed. In that bill, which is really like, as Janet referred to earlier, like an agency bill. So the 437 was actually the agency bill for the Florida Housing Finance Corporation. There were a lot of other things in that bill, a lot of different cleanup things and so on. But also in 437 is something that is really bigger than cleanup. We're having a major shift in the way that the Florida Housing Finance Corporation is allocating its funding. They're moving to an RFP process from a competitive scored application. So this is sort of just starting, and Thousand Friends is working on that from a public policy angle. And I wanted to point that out to you, that it did pass as part of this bill, which does give them the authority, that agency, the Florida Housing Finance Corporation, to allocate their sale funds that we talked about earlier by RFP. And that's it for me.
Hey, Lester, if you
So
can
it's
hear us.
Lester, are you there?
Yes. Yes.
Okay, you're on.
We just wanted to conclude here by pointing out that although the 60-day legislative session is over, the process of considering legislation and finalizing all of these things that we've talked about today is ongoing. The legislative leadership controls the flow of bills passed to the governor. When they are received by the governor, he has 15 days to act on the bills. At some point, they will send the budget over to him, and this is a governor who has not been hesitant to veto things that he thinks are inappropriate use of state funds, and I think he will continue to do that aggressively this year. So for those of you who are participating in this webinar, if there are bills that we've talked to you that have passed, you should feel free to communicate with the governor's office, and particularly with the people in the governor's office of planning and budgeting on your thoughts on these bills, because the process is ongoing. And then, as Jamie alluded to in her comments, and some of Janet's as well, a lot of these bills, particularly ones that we were not in favor of, are likely to come up again during the next session. And because this is not an election year, the committee meetings will begin in the fall of this year in September. And for those of you who want to be effective advocates at the local level, this is the very best time to meet with your local legislators. They are in their district offices. We ready for questions?
Okay, this is Vivian Young again, and I wanted to let you know that the control panel for the webinar includes a questions box. We have a lot of good questions already, but we encourage you to submit more questions, and we'll try to stay on the line and answer as many as possible. If you can refer to either the bill number or the slide number and possibly the person you think should address the question, and we will answer as many of these questions as we possibly can. The first question was directed towards Lester in terms of the budget for greenways and trails, asking for a clarification on how much money was allocated for the Greenways and Trails project. Lester, can you still hear me?
Yes, that was money in the Department of Transportation budget. It is for a specific project to link some existing trails to acquire some land that would fill in the gaps of a proposed bicycle trail across the state, essentially from Pinellas County to Brevard County, as I understand it.
Okay. Our next question, I think any one of you could probably answer this. It's regarding citizens' property insurance. Wanting clarification about people in high risk will have no insurance. So if you could clarify who the changes in the citizen property insurance refers to, and I guess Charles addressed that question.
This is Janet Bowman. I'll answer the question. Basically, the provision that Charles mentioned limits the ability of citizens insurance to cover new construction that's seaward of the coastal construction setback line, which is, you know, the fringe between the vegetation line and the water that is the most sensitive edge of the beach. It doesn't prohibit development in that area. People can still develop. They would just have to get insurance on the private market. And it's intended as a measure to reduce the state's risk of exposure from high-risk insurance policies.
Okay. This question is for Charles. A person wanted to know when House Bill 319, which restricts mobility plans and fees, when it becomes law.
I think it's I think it's July 1st. Let me look. I've got a copy of the bill here.
While Charles is looking at that, we did have a question about the AICP-CM legal credits and CLE credits for attorneys, and also where the PowerPoint is. So this is information on that. And the PowerPoint is available at 1000 Friends website. And it says look at what's new, but actually it's under 213 legislative wrap-up, if you can look at that. And you'll get a link to the PowerPoint.
Vivian, House Bill 319 goes into effect upon the governor's signature, assuming he signs it or lets it go into effect.
Janet, we had a question about House Bill 999, where it limits water withdrawal when alternative uses are available. They wanted to know what kinds of alternative uses would trigger this prohibition. Would it be storage of partially treated wastewater or increase in water use efficiency?
This particular provision was directed at preventing water management districts from scaling back the amount, you know, the permitted CUP based on a utility having available additional alternative water, and it's fairly narrowly drawn to RO systems. So it's reverse osmosis as the alternative water supply.
Okay, and we have another question for Janet regarding House Bill 1145 on the sale of surplus land. when it talks about the negotiated direct sales, is there or will there be any oversight to ensure that we are at least getting a reasonable percentage of market value?
Well, the way the bill is drafted, they're required for surplus sales to conduct appraisals. And there's some provisions governing the number of appraisals depending on the value of the property. But there is no limitation on the percentage of fair market value that they can offer or sell a particular parcel for.
Okay. This question is for Jamie. There was a bill that would have combined the separate CDBG programs into one and called for new rules. The person wanted to know what happened to it, and if it didn't pass, is rulemaking still possible or moving forward?
I am going to have to look into that and get back to that person. I do not know.
Okay, we'll try to get back on that issue. We have another question for Jamie, but I think others might chime in. They wanted to know if there's any recognition this year of the need to address sea level rise because of its disproportionate impact on low-income people due to flooding impacts.
The what rise?
Sea levels.
Okay.
In other words, was there any effort to look into sea level rise as in terms of its impact on lower-income Floridians?
Not to my knowledge.
Oh,
Okay. Are there any veto requests expected by the groups represented today? In other words, is there any legislation that anyone is looking to call for a veto on at this point?
On the stuff I talked about, this is Jamie on housing, the answer is no. We expect the governor to sign it.
This is Charles. I don't expect us to ask for vetoes on anything at this point.
This is Janet Bowman from the Nature Conservancy. I don't expect that we'll ask for any vetoes.
This is for Jamie. Regarding the SHIP funds, what do you think the reasoning was behind decreasing the administrative cost to 3%? Also, is there a way to change certain costs that aren't administrative to the program?
That's a really great question. I fear that we have legislators, some legislators, who thinks that local governments, well, they don't like local governments. Let me just put it that way. I think that we see that when there's an appropriation of $20 million to a particular developer, to Habitat, but not to the local governments, $40 million for the whole state, and then reducing the admin to $3 million, I think that they're just not comfortable that local governments are doing the best job that they could, which is one of the reasons why we're going to be working on that issue between now and, as Lester talked about, when we start meeting with legislators in earnest early fall, because local governments have been doing an excellent job in keeping the admin down on administering the SHIP program. It is going to be a challenge for them to administer with 3%, but we will be working with local governments on ways to address this, and sometimes that involves using subcontractors as well and partners in their community.
This is a question for Janet. Somebody wanted a clarification or more detail of the impact of House Bill 999 on gas lines.
The specific provision addresses, I think, major interstate natural gas pipelines that are coming into Florida, providing that they're subject to the expedited permitting process. So it doesn't change any of the permitting standards per se. It's the administrative process by which permits can be challenged and timeframes for responding to the permit application.
This is for Charles, asking for clarification on Senate Bill 528. They say it allows, they want a clarification, does it allow counties to accept amendments for ag enclaves without parcel size limits and an application timeline?
Maybe Lester recalls the specifics. I don't. What that did was it kept in place the ag enclave restrictions or limitations, but it specifically repealed some changes that were made last year. Lester, I don't know if you recall, I don't have those particular changes in mind. They were structured such that they only applied to one landowner in St. Johns County that could qualify, and that is specifically what got stricken.
That's right.
Okay. This is a question for Lester and Janet regarding the $50 million for Florida Forever from sale of surplus state lands. Is there any likelihood that the state will actually identify lands that total up to that value, and that they will actually sell those lands? In other words, is the $50 million part of the bill actually going to be acted upon?
Oh, Lester, you want me to answer that question?
Well, I'll
answer that question.
System.
I doubt that the inventory, the identification and sale process that DEP is about to undergo will result in $50 million of trust fund money being available to buy new land during this current fiscal year. It takes a significant amount of time to review parcels that are identified as potentially surplus. The decision to surplus has to go before the governor and cabinet, and that takes months to schedule and to get those decisions made by the governor and cabinet. So I would be very surprised if $50 million is available.
I agree. I would just add to what Janet said. I think she said it well, that these kind of land deals take a long, long time to accomplish, both from a real estate transaction perspective, also from the administrative perspective of having to be approved by the governor and cabinet in their role as the board of trustees. I do think it's important, though, that the Division of State Lands is about the business identifying potentially surplus lands. I agree with Janet. I think it's unlikely that that will result in any appreciable revenue in this fiscal year, but it could set the table for some money going forward.
And I would add that during the last year, the water management districts have been going through a process of evaluating their inventory for surplus. And if you look at kind of what they've come up with, at the end of the day, it ends up being several, a handful of parcels as opposed to sort of a significant divestment of land.
But if we go through this review, and the same thing is true of the lands that are held by the state, maybe we can begin to break through this perception the state owns too much land that's not useful or available to the public, and we can focus the legislature's attention on the need for general revenue funding or use of dedicated revenues as is proposed in the Florida Water and Land Legacy 2014 constitutional amendment.
Right. And I would point out that, if you add up the money that was appropriated of general revenue, trust fund money, there's $31 million for Florida Forever, rural and family lands, and then there's, the other chunk for the bike trail across Florida that would have been, under other days funded from Florida Forever. So that starts to add up to, you know, a fair chunk of money that could be well spent this year.
That's a really good point. I agree with that.
We have several questions for Charles regarding House Bill 319. One of them is, do you believe the existing local mobility fee programs meet the dual rational nexus test? And you might want to explain what that is for some of the listeners.
Well, not being a lawyer, I feel totally qualified to answer that. I think the ones that are in place, you know, definitely would meet that test. I may get Janet or Jamie, our lawyers, to define that term for you, but I think that's pretty much a term of art these days, that most impact fees have to meet, as well as any of the you know, concurrency-related fees. So I think the safest answer might be that we intend, I believe I'm right, Vivian, to have a future webinar that's going to feature the Pasco and Alachua mobility plans, and maybe that's a question we can work with them. But I know that their legal staffs were extensively involved when those ordinances were passed.
Okay. We had kind of a procedural question on House Bill 319 about how the House and Senate have to pass essentially equivalent bills before it becomes law. And it's a question that 319 passed, but the Senate version did not, and they wanted to know how that works.
Well, for most of the bills, you know, they just have to, they can either be identical, and usually, you know, you can pass one or the other. You don't usually see both versions of the same bill pass. So usually one, you know, either the House or the Senate will take up its companion bill and substitute it if it chooses to do that, or, you know, can ask that they accept, you know, the House or the Senate version. Lester, I'm sure there's a more articulate explanation of that.
Good explanation. That's a good explanation. We could use the House Bill 999 example. Janet spoke eloquently of the two horrible provisions that were taken out of that bill by the Senate, one relating to the preemption of local fertilizer ordinances, and the other the preemption on the 298 districts. Both of those things were in the House bill. The House passed the bill and sent the bill to the Senate. The Senate took up the House bill rather than their, I think their bill was 1628 if my memory serves me correctly, but it might not be right now. Anyway, they took up the House bill. They had amendments filed to the bill to take out the fertilizer preemption and the 298 preemption. They passed that bill and then sent it back to the House, and it was late in the process, the last day of the session, again, as Janet had one of the last bills that passed. And so the House had the choice of taking the Senate version of their bill, which did not include those two preemptions that we discussed, or trying to put the preemptions back on and send it back to the Senate and make the Senate take it or leave it. So it became an issue of timing. But that's generally the way it works. Either body would send the bill to the other and be amended and sent back. Rarely they're identical bills.
Right, and just to close the loop on House Bill 319, the Senate companion, Senate Bill 972, was passed by the Senate. And like Lester said, they, instead of moving that forward, they chose to take the House bill, which was essentially the same bill, or was the same bill at that point.
Okay, thank you. We've got another question for Charles about House Bill 319. What is the difference between a mobility fee and an alternative system that is not mobility fee based?
Well, that's a good question. There's no definition for what that entails. I think most people have seen the mobility fee as the most likely example of what you would have if you decided not to go forward with concurrency. I know I don't know of any other systems out there, but it's up to an innovative local government to propose one. But the way the bill was written, It won't matter whether you have transportation concurrency or a mobility fee as we currently understand them or something else. You will be required to use that pay-and-go provision that now is in statute.
Okay. We have a couple of questions for Jamie. One question was what was done with the balance of the Attorney General settlement funds?
Oh, okay. So there, first of all, let me back up on that question and tell you that there were $60 million of the Attorney General funds that were appropriated prior to the legislative session through the LBC, the Legislative Budget Commission.
Yes.
And commission. And 10 million of that went for housing counseling, which will be administered through the Florida Housing Finance Corporation. And then about the money that, and another 35 million went for a down payment assistance program to be administered through the Florida Housing Finance Corporation. There's all kinds of monies that went to state courts, also to the Attorney General's office. There's money that went for expediting foreclosures. There was $9.1 million that went to the Florida Prepaid Tuition Program, $5.2 million state court system for technology solutions to speed up foreclosure cases, $16 million to state court system for resources to reduce the backlog of pending foreclosure cases, another $9.7 million to the state court system to the clerks of the court to expedite the backlog of foreclosure cases. That, I think, probably adds up to the approximate $200 million plus the $60 million prior to the legislative session that is appropriated, that was appropriated from what we call the discretionary monies that were part of the AG settlement. Now, everybody should know that this is a very small portion of the AG settlement. The bulk of the AG settlement is being administered through the AG's office, and we're talking about billions of dollars that are supposed to help people who were hurt by the bad actions of the banks, which ended up in them losing their homes. And the Attorney General has a terrific website for all of this information, so I think it's very user-friendly. It's really terrific. So all of that information is up there on the AG website.
Okay, and Jamie, another question for you. Somebody wants to clarify the portion of tax exemption for nonprofits that partner with a for-profit. They're asking, does the nonprofit have to have an active role in the property to maintain the tax exemption?
So a property tax exemption for a nonprofit is if the nonprofit owns the property. First of all, it has to be one that's classified as a 501c3. And so it's not just a nonprofit under Chapter 617, but it's a tax-exempt organization under 501c3. And they have to own the property, and it needs to be used for affordable housing. So if the structure cannot be a partnership in terms of ownership, there would need to be 100% ownership by the nonprofit to receive an ad valorem, and that's what we're talking about, ad valorem, a property tax exemption. I assume that's what the questioner is saying, the ad valorem tax exemption.
Okay. And Jamie, one more question for you. Were there any significant changes to the state's competitive community development block grant program?
I think I don't know on the CDBG program, but someone else asked a question about that, so I'm going to check on what happened with the CDBG program. I know there's been an effort that started a couple of years ago with the whole Department of Economic Opportunity to change how the small city CDBG program works, and I did not follow that this session, so I'll need to look into that.
Okay, Janet, this is for you. I think it looks like it's looking for a clarification. It's talking about the 3 review limitation in House Bill 999. They're saying it looks like it only affects applications filed by licensed engineers, landscape architects, geologists, and surveyors, mappers. It does not include building permits, and I guess they're looking to see if that's your interpretation as well.
Yes, it specifically excludes building permits, and applicants can waive the 3 limitation. But you know, it's certainly an incursion on local sort of home rule ability to process their applications following their own procedures.
And another question for you, Janet, House Bill 7087, does it reference existing imperiled or threatened species management plans as wildlife BMPs? And is it limited to certain classes of wildlife, or does it authorize wildlife BMPs regardless of species listed by the Fish and Wildlife?
It's not specific because the sort of path is for FWC and DACS to enter a memorandum of understanding and then to adopt the BMPs by rule. So the rule will define, you know, which species are being covered and what the process is.
Okay. This is a question related to Restore Act, which I don't think we covered, but I don't know if anyone would like to answer it. What do you see as the impact of House Bill 7007 related to the Restore Act project selection due to the creation of Triumph Gulf Coast?
Yeah. This specific, there was language that was added in the Senate but later removed that would have had an impact on the selection of Restore projects, but that was removed, and the only language in the bill now that talks about the Restore Act is that the Auditor General is given some authority to audit local government expenditures of Restore funds, which probably when the feds, the Department of Treasury adopt their rules for Restore, I'm sure there'll be federal audit requirements as well. But the whole project selection process is not included in the Triumph organization.
Jamie, a couple more questions for you. Can you estimate a time frame of how and when SHIP funds will be allocated, and at what point nonprofits should consider applying for funding?
So the Florida Housing Finance Corporation will distribute the SHIP funds. I think, as they always do, it's electronically transferred probably starting July 1. I would imagine that it would go out after that, but I haven't touched base with them to ask them that question. But I don't imagine there would be any reason why they wouldn't start going out immediately after July 1. Of course, you can check on that by getting in touch with the Florida Housing Finance Corporation to find out. The Florida Housing Coalition also will be doing webinars on exactly how this appropriation is going to work, if anybody is interested in that. And then you would go to the Florida Housing Coalition website for that, which is flhousing.org, to get that information, but it's not up yet. And so as far as nonprofits applying, there is no reason why a nonprofit who wants to apply for funds shouldn't go ahead now and get in touch with their SHIP office, because most all SHIP offices work with, waiting, they have everything in place, just waiting for the funds to come in and then can just distribute. So there isn't any reason really to hold off.
Okay, and not to put you on the spot, Jamie, but somebody asked for the Florida statute that allows for ad valorem tax exemption for 501c3 owned properties. I don't know if you know that off the top of your head.
Yeah, so the one we were talking about is 196.1978. And there are a number actually of statutes that deal with nonprofit ad valorem treatment, like there's also 193.018 that has to do with community land trust, which is a particular kind of a nonprofit that you may have in your community. And I believe it's also 193.193 to look at off the top of my head. We could start there.
Okay. Somebody is making a statement here. I don't know if anybody wants to respond to it. They were just saying that Senate Bill 682, fossil fuel combustion products reuse, that several groups are calling for a veto due to water quality impacts. And I know that wasn't covered today. I just wanted to mention that somebody had brought that statement in. This is another bill I don't believe that was covered today. It says, does Senate Bill 1258 apply to mobile homes?
Off the top of my head, don't know what 1258 is.
Okay.
I'll find out and get back to you.
Okay. This is another question, probably for Janet, regarding the failed bill that would have required local governments to sell land prior to acquiring land. Was that for conservation lands only or for lands for any use? And what is the rationale for the state to consider creating such a mandate for local governments?
It was for conservation lands, and I think the philosophy behind it was one of the sponsor, which was that the state and or local governments own too much conservation. Well, there's too much state-owned land, and that too much off the tax rolls, and so the idea is to put some of the land back on the tax rolls before you bought additional conservation land.
Okay. Charles, I think this is a question related to House Bill 537. Regarding exemptions for 5 or more parcels, is the cumulative size of parcels or ownership a consideration?
The cumulative size of the parcel, I don't think it makes any difference how big or small. It's just so that it applies to more than 5 individual, parcels in that community. Okay. There's no size specification if that's what the person was asking about.
Okay, and there's a long question regarding House Bill 357, manufacturing competitiveness. It says that they believe that the 60-day limit to take action applies to state-level review and does not apply to local government review. Do you think that since the bill essentially allows local government only a single chance in terms of review, I'm trying to paraphrase here, that local governments will be shy to use this voluntary program?
Well, first of all, it is voluntary, so no one is required to use it. We had, when we initially followed this, we thought this was very similar to the existing expedited permit process that's still in place and, is available to people. It does only apply to development orders, which is interesting. It does not apply to comprehensive plan amendments, which might also, have an effect here. I don't recall the position the cities or the counties took on this bill. So I don't know. I don't really have a response to whether local governments would be trying not to use this.
All right. And as a follow-up, as an alternative, will local governments load up their master plan application review process with all sorts of detailed requirements that the developer normally encounters toward the end of the process, not the beginning?
It's possible, although there is a requirement in there that DEO look at the ordinances that local governments adopt, and it does have general provisions, whether DEO reviews it or not, that talks about minimizing subsequent development approval. So it wasn't clear to me who would rule a local government's ordinance inconsistent with the with the state statute that this bill would now adopt. I think that's probably something that's going to have to evolve before we know the real effect of it.
Okay, that was our last question. We'd like to thank all the panelists for participating and for all the people who attended and asked such wonderful questions. I did want to let you know that our next webinar is going to be Wednesday, June 12th, and it's particularly timely. It's on the Florida Greenways and Trails Close the Gap campaign, and this is the project that is in the budget for $10 million a year for the next 5 years. And Dale Allen from the Florida Greenways and Trails Foundation is going to be discussing that program. So if there are no more questions, we thank everybody for participating. And the PowerPoint is posted online. We have recorded it. In the next day or two, the broadcast will be online. And we thank you all for attending. Goodbye.